Hello.
You can pronounce people not the video. You can
For judgment, item number 1.
Reports. Accordingly, we are of the opinion that the direction and observation made in the impugned judgment and order dated 26/6/2022, passed by the land single judge in WPC number so and so, and the judgment and order dated so and so, passed by the land single judge in review petition number so and so, does not call for any interference. For the reasons stated above, this writ appeal being devoid of merit stand dismissed.
From the supplementary cause list for judgment, item number 20.
For the reasons stated above, and having held that the DB's court under the rule has no power to seek an appeal over the decision of the village council, the impugned decision dated 22/10/2021 passed by the DB's court is hereby set aside and quashed. The matter is remanded back to the Court of Additional Deputy Commissioner Chipo Bozo Kohima to decide the issue raised by the appellant in the appeal filed before it on so and so on merit as per the provision of law, equity, and good conscience. The writ petition stands disposed of.
Objection, Lordship. Objection, Lordship. May it please, my lord. Lordship, I may be allowed to make an unlisted motion, Lordship. I have filed this morning, Lordship.
So
There's
what
actually-
is about?
There is urgency in this case, Lordship, because it is likely that notice has already been issued to me by the Income Tax Department, Lordship, and my bank accounts may be freezed, Lordship. It's likely to be
No,
freezed.
no, that may be listed. So probably this has to be mentioned before the,
Senior Judge,
yes.
I have already done that, Lordship, and
Then
he
let it
has-
be listed on Monday.
he has sent it over to this.
Let it be listed. File it, it will be listed on Monday.
My lord, because there's, in fact, yes, there is urgency, Lordship, in this matter.
No, it can't. No, so file it.
The filing has already been done,
Let it be listed on Monday.
Lordship.
Yes.
Yeah, please, the Lordship.
Yes.
Lordship, I make the mention item number 3.
Item 3.
Lordship. 3 and 4.
Yes.
Lordship, since the state respondent has been included as a newly respondent, Lordship.
Yes.
I'm allowed to take some time to take a necessary instruction.
Mr.
I, Jamir, Lordship.
Counsel for the petitioner is present. Mr. Jimomi, there PP, sorry, there is PP.
Lordship.
Okay. PP submits that the state has been newly included in the instant case and instead can and praise for some time to go through the petition laws. As prayed, list this matter after
3 weeks.
3 weeks laws. Okay.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 13. I'm for the respondent number 1.
1-3.
1-3, yes.
Counter noted file.
Your Lord, Your Lordship, I appear for the petitioner in this matter.
Yes. Counter noted file. Counter noted. So what?
I'm for the respondent number 1.
Respondent, what do you,
I pray to kindly grant us 3 weeks time to file counter.
Okay, they are praying for 3 weeks time.
Your Lordship, yes, Your Lordship, I want to request that interim order shall continue till
Okay.
next.
You are Mr.
Harsh Jadon. Your Lordship, petitioner is present in person through virtual VC.
Rajat Patnagar, resolution petition present in person, Lordship.
Okay. Hers?
Jadon, JDON, Your Lordship.
So VC, stop. Mr. Azamir, Direct Counsel for the respondent, prays for 3 weeks time
2 weeks time.
to file counter. The prayer is allowed. List this matter after 3 weeks. Stop.
Your Lordship, the interim order.
Interim order passed earlier shall continue till the next date. Okay.
Highly obliged, Your Lordship.
List, Your Lordship.
Yes.
Lordship, I would like to mention item 17. I'm representing the.
Counter noted file.
No, I'm representing all the state respondents here.
17?
Allowed 3 weeks time to file state counter.
Yes.
No objections, Lordship.
Mr. Santenga, Direct Counsel for the petitioner is present. Mr. Moa Imchen, Direct Senior Government Advocate, prays for 2 weeks time to file
weeks time.
counter. 3 weeks time to file counter. Stop. The prayer is allowed. List this matter after 3 weeks. Okay.
Yes, okay.
Mr. Lordship. Your
Yes.
Lordship, I beg to mention item 8, Your Lordship. 3 weeks time may be granted to.
Counter noted file.
Your Lordship, I'm sorry, item 9, Your Lordship.
Item 9.
Yes, Your Lordship. 3 weeks, Your Lordship.
9 also noted file. Okay. Miss, Direct Counsel for the petitioner is present. Miss,
In a holy, Your Lordship. In a holy, Your Lordship.
Jana Holland, Learned Government Advocate, appearing on behalf of the respondent, prays for 3 weeks time to file counter. The prayer is allowed. List this matter after 3 weeks. Okay.
Your Lordship, similar prayer for 10 and 11.
10 and 11 also
Counter
noted file.
last
Yes,
time,
I've
yes.
seen. Okay, similar order, huh? 10 and 11. Yes,
12
Similar.
as well, Your Lordship. 12 on behalf of Tiba, Your Lordship.
12 also noted file. I've seen.
Yet to receive instruction.
Well, the interim may be continued.
Okay, in 12. Okay, Mr. Iralo, huh? Direct Counsel for the petitioner is present. And Ms. Swansea, appearing on behalf of the state respondent, prays for 3 weeks time to file counter affidavit. Stop. The prayer is allowed. Stop. In the meantime, the interim order passed earlier shall continue till the next date. Okay.
Your Lordship, in item 14 as well, Your 3 weeks time may be granted.
Yes,
to file.
14 also noted file. I've seen.
Much obliged.
14 also. The counsel for the petitioner is same, huh? Similar order.
Lordship, I'm appearing on behalf of my senior Supamwati.
Okay. Appearing on behalf of Supamati, Walinani counsel for the petitioner, huh? And her name, same prayer, and then the prayer allowed. This is matter after 3 weeks.
Much obliged, Your Lordship.
Okay.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 6, the fixed item. Lordship, here, my senior counsel, due to unavoidable circumstances, he had to go for his mother's checkup. So, with the consent of the opposite party, if this
Okay.
matter can fix.
You brought the complaint into record. Yes, sir.
You also may be fixed on the 30th of June, 30th of May.
30.
30.
That is Thursday.
Okay. Miss, yeah, Mr.
Abel Ayemi.
Your name is there?
Yes, Lordship.
Okay, Learned Counsel for the petitioner is petitioner prays for. And petitioner is present, huh?
John.
Mr. Iralo, and you, okay, Mr. Jimomi, for the state, PM, Learned PP for the state, and Mr. Hiralu, learned counsel for the respondent number two are also present. As prayed for by the learned counsel for the petitioner, list this matter on 30. Okay.
Lordship, there is an
You have
interim.
received the copy that who brought the complaint into on record? Have you received the copy?
I've received.
Okay.
Lordship, there is an
The interim order,
interim pass.
the interim order passed earlier shall continue till the next date. Okay.
Oblige you, Lordship.
Lordship, I beg to mention item number 5.
Item
5.
5.
Your Lordship, this matter relates to minimum scale of pay.
Okay.
So a committee has been constituted to look into the matter.
Hmm.
But because of the earlier Lok Sabha election, that could not, the committee could not meet. And thereafter, again, the urban local bodies election, Your Lordship, for the forthcoming, because of that,
Okay.
model code of conduct is
Okay.
enforced. So let this matter come up after 26th of June. Lordship.
Okay. Ms. Sophie, an additional AG, for appearing for the respondent, submits that although the committee has constituted, but due to URL, due to the due to
ULB election, Your Lordship.
okay.
Yes. Urban local
Implementation of
bodies.
urban local body election, the committee could not sit and pray for listing this matter after the election of
26th of June.
after 26th of June. Stop. The prayer made by 26th of June. Stop. The prayers are allowed. Mr. Vati Jamilani, counsel for the petitioner, is also present. Stop. List this matter after 26 to be fixed by the registry.
Much obliged.
Okay.
Oblige.
After 26 on the date to be fixed by the registry. Okay.
May I please, Your Lordship? I
Yes.
beg to mention item number 7,
7.
Your Lordship.
7
Yes.
already mentioned. 7 not mentioned. But it was 9. So 7 you are for respondent.
1 to 27, Your Lordship.
Respondent
1 to 27, Lordship.
1 to 27.
Lordship.
Okay, yeah, sorry. I was looking at 6. Yes, counter not yet filed.
I beg this honorable court to please grant me 3 weeks time,
3 weeks. Okay.
Your Lordship.
You are Miss
Petition, Lordship.
Miss counsel for the petition.
Oh.
Miss.
Atolenyo Kezo, I'm appearing on behalf of my senior Elevil Zhao.
Okay. Appear on behalf of Elvil Zhao, Learned counsel for the petitioner. And you are Mr.
Kiki,
For the respondent 1 to 27, prays for further 3 weeks time to file counter affidavit. The prayer is allowed. List this matter after 3 weeks. Okay. In the meantime, you file, huh?
Oblige, Your Lordship.
Okay. Yes.
My blessed Lordship. Lordship, I beg to mention item number 15. Lordship, we kindly allow 3 weeks time to file affidavit. Kindly allow 3 weeks time to file affidavit. And for the state.
State, yes, it said
Okay.
not yet filed. Otherwise, rest already filed.
I'm
You're
for
for?
respondent number 5, Lordship.
5 already filed.
Yes.
Yes. Learned counsel, Mr. Learned counsel for the petitioner is present, huh? Miss
Pichano.
Learned government advocate prays for how much time?
3 weeks time.
Further 3 weeks time to file counter affidavit. Okay. Miss
K. Lilisu for respondent number 5.
appear for respondent number
5.
5. So, is prayed for by the Learned council, the Learned state council. List this matter after 3 weeks. The list this 3 weeks.
Lordship.
Okay, after 3 weeks. In the meantime, you file.
Lordship.
Okay.
Please, Your Lordship, I beg to mention item number 1, Your Lordship. I'm mentioning on behalf of Ms. Lucino for the petitioner. She's indisposed, Your Lordship, so if this matter can come up after 3 weeks.
Yes, LCR, just we have received LCR. Okay. Miss,
3 weeks.
Learning Council for the petitioner. Praise for listing this matter after
3 weeks, your
3
lordship.
weeks. To which Mr. Jimomi Learning EP has no objection. The prayer, accordingly, the prayer is allowed. List this matter after 3 weeks.
Like your
Okay.
lordship. May I please, your lordship?
Yes.
I'd like to mention item number 2.
You also counter not yet filed.
Lordship, in fact, this
Great
is
for-
civil revision, Lordship. So we will not be filing.
So earlier, I think you have prayed for the private respondent has, I think, prayed.
Lordship, private respondent, they have not engaged in any counsel, Lordship, and they are not appearing in this case.
Okay, who made a prayer? Item
On the
2,
last occasion,
item 2.
Lordship, this matter was listed for admission hearing, Lordship.
Okay. Okay, someone made a prayer, huh? Yes. You sought for filing affidavit in opposition, sought for 3 weeks' time earlier.
Lordship, in fact, this is revision, so we will not be filing an
So, for a 30
Lordship.
reflected, okay.
Lordship.
So, you
Lordship,
want this matter to be listed after?
after 2 weeks.
Okay,
I'm appearing on behalf of my senior Supamati.
and on behalf of Lucina. Okay, Miss,
Berta Tep.
appearing on behalf of Miss Lucina, Learning Council for the petitioner. Praise for listing this matter after 3 weeks,
2 weeks.
after 2 weeks, stop. Mr. Jimomi Lanet, EP for the state is also present. As prayed, list this matter after.
Lordship, on behalf of Supamati.
Supamati,
Yes, Lordship.
sorry, so this is Supamati. Walling, huh? Okay. As prayed, list this matter after 2 weeks. Okay.
I also beg to mention item number 8.
8 also. Reply noted.
Kindly list this matter after 3 weeks to file our
For filing
affidavit in-
reply.
Yes, Lordship.
Miss. Here your name is there,
Yes, Lordship.
Learning Council for the petitioner. Praise for further 3 weeks' time
Yes, Lordship.
to file affidavit in reply. Stop. Miss Mika, you are for, how can, state first, huh?
Yes, Lordship.
Miss,
Pinahuli.
for the Learning Council, Learning Government Advocate for the respondent number, state respondent and Mika for respondent number
6, Lordship.
are also present. Stop. As prayed, comma, list this matter after 3 weeks. Okay.
For motion, item number 21.
Lordship,
21.
despite the fact that the petition is bulky, the facts are
Yes,
quite simple, Lordship.
okay.
The petitioners, consequent upon the approval by the government of Nagaland, Lordship. As
They're
well
out
as,
of job now?
yes, Lordship.
Okay.
The government accorded approval for their appointment, Lordship, as operation and maintenance staff, Lordship, in the PHC department.
Prior to this approval, whether they were earlier already in the service as a contingent or something?
No, Lordship.
Okay, new
Yes, new.
appointment on the basis of, on what basis they were appointed? Approval
These
given,
are, yes, fourth grade service only, Lordship. So, division wise,
on the
recruitment
basis
was,
of the interview or just?
I believe so, yes. Division wise recruitment was conducted, Lordship.
Okay. Interview was conducted? No.
I think so, Lordship.
It appears no interview was conducted.
Lordship.
Oh.
Now, Lordship, if I may be allowed to take my lord to annexure 1,
Okay. Page,
page 44.
yes. Oh, yes.
Yes, I may be allowed to read this, Lordship.
Hmm.
To the so and so, subject administrative approval for filling up of vacancies of operation and maintenance staff.
Hmm.
Sir, I am directed to refer to your letter so and so dated 17/10/2022 and to convey herewith the administrative approval to the proposals for filling up of vacancies and of O&M staff in the department in compliance to PNR OM so and so in fresh manner under the following service conditions. These are important, Lordship. 1. That their pay and allowances shall be as per the revision of pay given at clause 2I of the OM number so and so dated 17/3/2015. 2. The appointees shall be on probation for a period of 2 years. 3. On completion of the probation period, all appointees shall be subjected to suitability tests. This suitability test shall be conducted at division level and the divisions shall maintain their seniority based on merit. 4. Only those O&M staff who qualify the suitability test shall be eligible to be considered for regularization against vacant sanction posts based on the merit list division-wise. Now, Lordship, consequently, the petitioners were issued appointment orders, which I have annexed at annexure 2 to 73.
Whether, just a minute, you have you annexed this order? The order dated 17/10/2022. What was this letter for?
Lordship, I am not privy to this order, Lordship.
Hmm.
I don't have a copy of this, which is why I could not annex in my
Okay.
writ petition, Lordship. However, Lordship, we can make out that this office memorandum has amalgamated, Lordship, and that this government approval was accorded in accordance to this office memorandum, Lordship.
Because I am curious to know if they were already in the service on the contract or
No,
contingent.
Lordship, no,
Okay,
that
then,
was not.
okay. Yes.
Now, this is the appointment order, Lordship.
Yes.
Annexure 2, page 45.
Hmm.
Here also, Lordship, the service conditions are
Hmm.
given at serials 1
Same,
to
same
3.
condition given.
Yes. The appointment conditions, Lordship, if I
Yes.
may be allowed to read.
Hmm.
Point 1 and 2 is important, Lordship. 1. The appointees shall be on probation for 2 years. On completion of the probation period, all the appointees shall be subjected to suitability tests. This suitability test shall be conducted at divisional level and the division shall maintain their seniority based on merit. 2. Only those O&M staff who qualify the suitability test shall be eligible to be considered for regularization against vacant sanction posts based on the merit list division-wise. So, Lordship, this appointment order was issued on 12th of September last year, 2023. Now, Lordship, they were to be on probation for a period of 2 years. After that, Lordship, suitability test was to be conducted. And if they were found to be unsuitable,
This approval was granted on, sorry, this was in 2022.
yes, this was on 22, Lordship,
Appointment on
and
23.
the appointment order was issued in the year 2023,
Hmm.
in the month of September.
Yes.
Now, Lordship, as per the conditions of appointment,
Hmm.
the service conditions, they were to be on probation for a period of 2 years, Lordship.
Right.
And after that, suitability test was to be conducted. If they were found unsuitable, Lordship, it goes without saying that they'll be
Yes.
terminated.
Yes.
Now, however, Lordship, the government have issued impugned office order, which I have annexed annexure 74 to 145. Lordship, if I will be allowed to take my lord to annexure, just reading a single, because since all these documents are identical, Lordship, except
Yes.
for the
Yes,
change
yes,
of the
yes,
name of
yes.
the employees.
Please.
Page 120, 9, Lordship.
Mm.
This is the impugned office order. If I may be allowed to read, Lordship.
Yes, yes.
Dated 23rd February 2024, office order to so and so. This is the petitioner number 1, Lordship. In pursuance to PNR Department OM so and so and government approval OM number so and so, and in order to keep the O&M staff within the ceiling limit fixed by the government, the department, in the interest of public service, with regret would like to inform you that your appointment by office order so and so is hereby terminated. Therefore, please be advised to consider this as 1 month's notice, and your services will be terminated with effect from 1/4/2024.
It's already effective.
Yes, Lordship.
Okay.
Now, Lordship, I have filed RTI application also, Lordship. Whether the is access appointment or not, whether that part I'll take my lord later on, Lordship.
Hmm.
But Lordship, it goes without saying, Lordship, that when the government has issued appointment orders and appointed me on the condition that suitability test shall be conducted, Lordship,
Yes. Mm.
after probation of 2 years is completed. And if I am found unsuitable, I'll be terminated, Lordship. That means, Lordship, on probation, the government may keep 500 employees, and if only 400 is required, then government will terminate those 100 employees who they are found, who they may find unsuitable, Lordship. So, Lordship, the issue of access appointment or reaching the ceiling or keeping a ceiling does not arise at all, Lordship, under the facts and circumstances of the case. Now, I, Lordship, have also submitted representation to the state government, Lordship,
Mm.
which I have annexed at Annex 146, Lordship. Since all the representations are identical, Lordship, and since it has already been submitted to the state respondents, Lordship,
Mm.
I have annexed a sample copy, and if, since the representation is already at the disposal of the state government, if it is required, Lordship,
Mm.
it may be called by this honorable court.
Mm.
The representations are no longer with us, Lordship. We have already submitted. And the date on which we have submitted, we have mentioned in the table given at paragraph 5 of our writ petition, Lordship.
Mm.
Now, Lordship, at paragraph 15, which appears at page 38 of my writ petition, Lordship,
Mm.
I have mentioned about an RTI reply, Lordship,
Mm.
where it is categorically reflected that there is no access appointment.
Mm.
Of course, under the facts and circumstances of the case, the issue of access appointment does not arise. But even in the worst case scenario, Lordship, let us assume that there is indeed access employment, and the reason given by the state is a valid reason, is a reasonable reason. Even then, Lordship, it is belied by their own RTI reply, Lordship, dated 9th of April 2024, which I have annexed at Annex 147. At page 219, Lordship. The details of the information that are given at page 222, 223.
Mm. Mm.
Now, whether the state government can lay down arbitrary service conditions.
So what is the position of the vacancy position according to you? The present, you say that there is vacancy
Lordship, at page 39, Lordship, of my writ petition, I have,
39.
yes, at page, I believe, Lordship, going to page 220 will be better.
Yes.
Yes, to rely on the document furnished by the
Okay.
State
What is the
respondent,
vacancy?
page 220. Lordship, they have given the ceiling and the number of vacancies, Lordship.
Yes.
So, as on March 2024, Lordship,
Hmm.
the last serial number 18, the ceiling is 2,000. The strength of employees is 1,916, and so there are 84 existing vacancies, Lordship.
Hmm.
So, Lordship,
So
even before the
this was
termination was affected, Lordship.
the termination was issued during February,
Yes, Lordship.
and it shows that 17 serial number 17
Yes,
February is showing minus 29,
yes, Lordship.
and then at that point of time probably
Yes,
this was issued.
yes, Lordship.
Yeah.
Now,
Okay.
if there was minus 29, Lordship,
Hmm.
I believe some may have retired because,
Thereafter,
yes, thereafter, Lordship.
okay,
And even if there is excess appointment, Lordship,
okay.
after we have completed our probation, Lordship,
Hmm.
so let the state government conduct suitability test, and if I am not found suitable, Lordship,
Right. Hmm.
I may be terminated. They
Right.
have every right to do that, but not at this stage, Lordship.
Yes.
And they have retained someone and they have terminated somebody else by applying different yardstick to similarly situated people. This is
So,
patently illegal, Lordship.
so all the appointees, how many of them are there? 72.
Yes, Lordship.
72 were appointed and 72 have been terminated.
Lordship, how many, I'm not sure how much were appointed,
Okay.
Lordship, and how much were terminated,
Yeah,
Lordship, but
yes,
yes.
yes, Mr. Angam.
Lordship, at this stage, notice may be issued.
Notice,
Yeah.
okay.
Lordship, I have an interim prayer, Lordship.
So now you see the termination is in the month of February.
Yes, Lordship.
So it has already been affected.
Yes,
Yes.
Lordship, but Lordship,
They're out of service now.
yes, Lordship.
Now then stay of what?
Lordship, the vacancies may not be filled up, Lordship, till the
Okay.
disposal of this
Okay.
petition. Because, Lordship, if
Against their,
yes,
against the
yes,
termination.
yes, yes,
against the
yes,
post.
yes,
Okay.
Lordship. Because if
That
that is
can-
done, the
That can be done.
complexion of the case will
Right.
totally change. Yeah.
Right.
And my filing of the writ
That
petition
can
will
be
be
That's,
without.
that's fair enough. That's fair enough.
Just,
Not the first interim prayer.
yes. That cannot be because
That's fair enough.
Add Mr. Santiago, Learned Counsel for the petitioners. I've also heard Mr. Angami, Learned Counsel. You're accepting notice on behalf of all the respondents.
Yes.
Okay, on behalf, appearing on behalf of the state respondent staff. The case of the petitioner is that consequent upon the approval of the government white letter dated 9/10/2022 and PNAR Department OM dated 3/10/2022, the petitioners 72 in numbers were appointed as operation and maintenance staff in the scale pay of rupees 3,000, that's 15,200 per month PM. Under the PH, all of them are same department,
Yes, same department.
PH department wide office order. Okay, department on various dates.
On various dates, Lordship, all these office orders were passed in the month of September 2023.
Okay.
On
within
4
the month of
different dates.
September 2023.
Yes,
Start.
Lordship.
one of the condition of the service condition of the appointment was that they will serve for 2 years on probation, after which they will sit for suitability test for regularization. Staff. However, by an impugn office, impugn order dated 23/2/2024. What is this? Another impugn order? 24. What is this 24?
Lordship,
Same, all the same.
yes, Lordship. It's just that, Lordship, the Annexure 145 was issued on a different date, Lordship.
Okay. And 24/2024. The service is a termination order only.
Yes, Lordship.
The service
Lord-
of the petitioners have been terminated.
We issued notice for termination, Lordship.
This is notice.
Yes,
Terminated with effect from 9/4.
yes,
It's order only.
yes,
Not
Lordship.
notice is order.
Yes, Lordship. Tahan.
However, before completion of the probation period by an order dated 23/2/2024 and 24/2024, the service of the petitioner has been terminated on the ground that there was an excess appointment. Although, as per the petitioner, where have you said that there is no excess appointment?
Yes, at paragraph 15, Lordship, to my writ petition. There I have also discussed about the RTI.
As per the petitioner, there is no any excess appointment.
Also, Lordship, it may be kindly mentioned that the ground of excess appointment should not exist when the department is to select the required number of employees after conduct of suitability test.
This is for the purpose of issuing issuance notice only. Not required. Okay, stop. Stop. Para. Issue notice. Returnable by 4 weeks.
Lordship, if it can kindly be 3 weeks, Lordship, because
3 weeks.
yes, Lordship,
3 weeks.
our source of livelihood is at stake, Lordship.
Okay, 3 weeks. Stop.
If a writer can kindly be given to the
Since
state
Mr.
respondents to file their,
accept notice on behalf of all the respondents. No formal notice need be issued. However, the petitioner shall furnish requisite extra copies to the Rana Council for the state. And Mr. Angami, stop. Para. List this matter after 3 weeks. In the mean. after 3
Lordship,
weeks,
yes.
Stop from para. Having regards to the submission, contention and the submission made by the Rana Council for the petitioner, the state respondent shall not make press appointment against a vacancy created by the termination of the petitioner, still the petitioner. Till the next date. Or what? This will be
Till the disposal of the writ
this the
petition.
till the disposal of the writ petition. I think this
Lordship.
okay without the leave of this court. We'll say
Lordship.
okay.
Or during the pendency of the matter.
Okay, during the pendency of this matter. Okay. List this matter after 3 weeks.
Lordship, if a writer can kindly be given that an endeavor shall be made by the state respondents to file their counter as soon as possible, Lordship.
Let the notice be.
Let
Lordship.
them file.
Obligement. Much obliged.
For motion, item number 22.
May it please your lordship.
Yes.
My lord, the petitioner herein is seeking appointment to the post of Chowkidar at ITPM Sub-Center under the establishment of the Chief Medical Office book on the basis of land ownership. So the brief fact of the case is that, my lord, in the year 1994, an agreement was executed between the landowner, that is the grandfather of the petitioner, and the government, whereby a plot of land along with the residential building was acquired by the government to set up the existing sub-center at IDPO, with a condition in the agreement that as and when any grade 4 post arises, then the first preference would be given to the landowner. Now, my lord, almost 30 years has gone by since the execution of the agreement. And during this span of 30 years, 3 posts has also become vacant. However, till date, no employment opportunity has been afforded to the landowner on the basis of land ownership and as per the agreement. Therefore, this petition seeking the intervention of this honorable court. And lordship, I'm also challenging the appointment of private respondent number 5.
Private respondent number 5 is not the landowner.
No, she's not a landowner, lordship. So recently, in the year 2022, the post of Chowkidar became vacant due to the demise of one Sri late Simon Yanthan. So the petitioner also applied for the post on the basis of land ownership. However, the private respondent number 5 has been selected in dishonoring the agreement dated 22/5/94, which is annexed at page 22, annexure A.
This is agreement.
Yes, lordship. For more clarity, the typed copy is at page 23.
Yes.
I may read.
So this is sale deed between
The grandfather of the petitioner, that is Sri Honsen Hansoy,
and
and the medical department.
okay.
So this was executed with a condition, lordship, that as and when any grade 4 post arises in the dispensary, then the first preference would be given to the landowner.
Okay. Yes. Notice can be issued. Pardon, miss.
Won't you be named, lordship? Lordship, there is also an interim prayer.
Lordship, the interim prayer may be considered on the next date. As per the petition, the respondent 5 was appointed on compassionate.
I've also heard Mr. appearing on behalf of the state government advocate for the respondent number
1 to 4.
for respondent number 1 to 4 staff. Issue notice returnable by 4 weeks. Since Mr. Government advocate accepted notice on behalf of the respondent number 1 to 4, no formal notice need be issued to the said respondents. However, the petitioner steps upon the private respondent number 5 by a registered post with AD within a week from today. Stop. List this matter after 4 weeks. Stop. Para, huh? So what interim?
To
Since
state the
the respondent number 5 has already been appointed when?
the appointment order was issued on 5th December 2023, Lordship.
So what interim order can be passed? So. Yes. Okay. Considering the contention and the submission made by the land council for the petitioner, the appointment of the private respondent number 5 shall be subject to the outcome of this writ petition. Hmm? Okay. List this matter after 4 weeks. Huh? Okay.
Much obliged, Lordship.
For motion, item number 23.
Yes.
Listen, Lords.
Yes.
Lord, this is a petition seeking a direction to the state respondents to consider the case of the petitioner for appointment on the basis of land owner, similar with the
Right.
earlier case.
Mhm.
Actually, what happened was in the year 2006, for establishment of the Beren district headquarters,
Hmm.
a large chunk of land has been acquired by the government. And MOU was signed initially
Hmm.
on 3rd of July 2006,
Yes.
which was followed by a agreement
Hmm.
between the landowners of 3 villages and the government on 30th October 2009. And as per the agreement, the government has to pay the compensation, land compensation.
Hmm.
And once the compensation is accepted by the landowners, then landowners cannot claim any appointment on the basis of landowner. That is also there in the agreement itself.
Hmm.
But unfortunately, no condition was inserted in the agreement that if the compensation is not
Yes.
paid,
Hmm.
then what happens? So in such a situation,
Hmm.
the land was acquired from 3 villages,
Mhm.
Parent village,
Hmm.
New Parent village,
Hmm.
and Kizangwa village.
Hmm.
We belong to Kizangwa village,
Hmm.
where an area of 510.62 acres have been acquired.
Hmm.
The total area is more than 1,000.
Hmm.
So it's a big chunk of land.
Hmm.
And we are concerned with the 510 acres of land belonging to Kizangwa village.
Mhm.
Now, we have submitted application for appointment as in the post of MTS, that is grade 4 post,
Hmm.
in the chief veterinary officer's office belonging to veterinary department.
Hmm.
Instead of considering the case of the landowners,
Hmm.
because the compensation has not been paid. First installment they have paid. After payment of the first installment, the entire area was occupied by the government.
Hmm.
But subsequent installment has not been released.
It was
Otherwise,
paid in the, some 2010.
as per the agreement, it has to be paid prior to 2010-11.
Okay.
First installment paid.
Paid.
That is pertaining to another village.
Hmm.
But so far as our village is concerned,
Okay.
the compensation has not been paid.
There are
So since
Hmm.
you are not paying any compensation,
Hmm.
so consider us in the grade 4 appointment.
Hmm.
That was our representation. Several representations have been issued. But the government has appointed the private respondent.
Have you also demanded the money to be paid due to you? No.
No. Because it is for the purpose of the government, it was secured.
It was as per the agreement, you were to pay. The government was to pay to you.
Yes.
So that was
exactly.
not paid.
Yes, that was.
No
not
notice
paid.
was issued.
No,
Okay, demanding the money.
no, Lord.
Okay.
Only since you have not paid the compensation,
Hmm.
provide us with some post. So that was not also
But
considered.
then that is not in the agreement.
So, yes, but it is a roadblock for us to stop the landowners.
Hmm.
But then what about the other non-landowners?
Hmm.
For them, there is no roadblock.
Hmm.
And no selection was conducted also. Okay, fine. If
That-
you are
that can-
conducting
that
any
challenge
selection
can be made
process,
Because unless there is an, in the agreement, unless there is a condition, then it will be difficult to demand on the basis of lane ownership. Because it was a selling of the lane.
no, going by that, if
Hmm.
that there is no condition in the agreement that you have no right,
Hmm.
then my question is,
Hmm.
what better right the other person also has then?
Yes, that challenge can be made, that it has to.
That
be
is what we
it
have
has to be
challenged.
advertised.
Lordship.
Yes,
No advertisement,
yes. So
just
have-
on the basis of
we
the
have made
approval
that
made by the
environment
chief
also.
minister,
Hmm.
it was appointed. Kindly see the Indian approval order of the government.
Hmm.
Very clear. Page 29, it's the type copy.
Yes.
Last paragraph, this has the approval of the Honorable Chief Minister Nagaland,
Okay,
dated
yes.
3/3/2024.
Yes, state respondent. So this. How this appointment can be made in this way?
Lordship, I can allot me some time to take instruction.
Okay, so notice
So
can be.
let the notice go, and in the meantime, the Indian approval and the appointment may be suspended till the return.
No, when it was appointed, it was in the.
It was 13/3/2024, that is the approval of the government,
Hmm.
and up to 2 days, 15/3/2024, the appointment has been issued. Thereafter, we have submitted representation.
Already
That was
appointed.
also not considered.
So she is the, he or she. Okay, they are in service now,
Yes,
two of them,
yes, but we are confined with serial number 1.
one. So, but she is in service now.
Illegally, she is holding the post.
Termination at this, and before hearing would be difficult. No, but then subject to, of course, the outcome of this writ petition. But we'll have to expedite for the time being, because she is already in service. Without affording opportunity,
No,
cannot.
Lordship, I would like to suggest in this way.
Hmm.
Since rightly or wrongly, a person has been appointed,
Yes,
then it should be allowed to continue.
no, for the time
If
being.
that is the case,
Hmm.
then what will be the relief?
Relief after the, you see, after.
And admittedly,
Hmm.
no selection process was conducted,
Yes.
illegally appointed.
Hmm.
And that is at the cost of the landowners.
Okay. Okay. Mr. City Jamir, non-senior advocate, assisted by Mr. Az Imchen, counsel for the petitioner. Stop. I've also heard Miss, and then, Learned government advocate for the the state respondent. You are for 1 to 4.
Lordship,
Yes, okay, stop, Issue notice, returnable by 4 weeks. Since Miss so-and-so, the government advocate accepted notice on behalf of the respondent number 1 to 4, no formal notice need be issued to the said respondents. However, you need extra copy. Okay,
Well, furnish it.
the petitioner herself furnish extra copy, extra requisite extra copy, extra requisite copy to the learned government advocate during the course of the days. Staff, so far as the respondent number 5 is concerned, the petitioner shall take steps within a week from today. List this matter after 4 weeks. Staff, para. The interim prayer shall be considered on the after hearing the parties on the next stage. Stop. However, it is made clear that the appointment of the respondent number 5 shall be subject to service of the appointment of the respondent number 5 shall be subject to the outcome of this writ petition. No?
we pledge.
Right.
My apologies, Lordship.
Yes,
There is an interim order in item number 2. So
Item
kindly
two.
let the interim order continue.
item 2. Interim order passed earlier shall continue till the next stage. Yes,
For admission, item number 16.
May I please, your lordship.
yes.
Your lordship, here the case of the petitioner have been regularized, your lordship.
It
Lordship,
appears
the matter may be
counter-
withdrawn.
Yes, sir. You are for the petitioner.
Yes, your lordship.
Okay. Counter noted file. As per
No,
the-
your lordship, what has
Office-
happened is that this incident petition is filed praying for regularization of the petitioner's
Hmm.
service, your lordship.
Okay.
What has happened is that the petitioner's case has been regularized, your lordship. So
Petitioner cases
regularized, your lordship.
already
Service-
regularized.
Your lordship,
Okay,
on 21 February 2024, your lordship.
okay,
Lordship, the matter will be withdrawn, your lordship.
okay. The Mr. Mojami.
I'm
Sorry,
sorry,
sorry.
I'm sorry, your lordship.
Yes, primary counsel for the petitioner submits that the service of the petitioner has already been regularized
Lordship.
by the state respondent. And as such, the state respondent by an order dated, order number. The submit state by an order number CEPHE EST WC stroke R 30 2016 dated 21 to 2024. The service of the writ petitioner has been regularized. Issued by the additional chief engineer, the service of the additional chief engineer and HOD. The service of the writ petitioner has already been regularized. And since, and thus the matter has become infructuous and praise for praise for, well, praise for allow him to praise to allow him to withdraw the writ petition staff. This writ petition stands dispose of on being withdrawn. Okay.
Much obliged.
Miss so and so are present also, huh? Okay. Okay.
For orders, item number 18.
May I please, Lord?
Yes, yes, no.
My lord, if lordship see the order for the office note 14/5/2024, the return of the notice is awaited.
Yes.
So therefore, my lord, seeing notice is
Yes,
service is awaited.
Hmm.
So let this matter be listed
Are
after.
Mr. A. Joe, Rani Counsel for the petitioner, appellant staff. The office note dated 14/5/24 reflect that notice upon respondent number 1.
One, sole respondent, my lord.
Okay, so respondent number 1. The service of notice upon respondent number 1 is still awaited.
Yes, my lord.
In view of the above,
Let it be listed after 4 weeks, my lord.
the case stand adjourned, which this matter after 4 weeks.
My lord, meantime, interim order passed on 18/4, maybe
The interim order
18/4.
passed on 18/4/2024 shall continue till the next date.
Much obliged, man.
What is the interim?
My lord, last para. Last para. Yes,
Last para,
yes, if lordship see. Having regard to the contention made in the petition.
18/4,
Yes,
it's not here.
18/4/2024.
It's not
Order.
here.
IA, in IA,
Okay, IA,
yes, my lord.
IA is not here.
IA.
Okay, that is fine.
My lord,
It's fine.
much obliged.
For orders, item number 19.
Yes. Here also probably service upon, return service is still awaited.
Lordship.
Hmm.
Lordship, if this matter may be done instead after 2 weeks.
Okay. So. Miss
And April.
N.
April.
Ruprio, Land Council for the petitioner, who is present. Mr. Jimomi, Land Council for also is present on behalf of the state respondent staff. The office not dated 30/4/2024. Reflect that. The return service upon the respondent number 7 to 11
7 to 14, Lordship.
or 7 to 14.
Lordship.
7 to 11 by the editing and then respondents to 7 to 14 is still awaited in view of the above. The case stand adjourned. If this matter after
2 weeks, Lordship.
2 weeks. Okay.
Obliged, Lordship.
For hearing, item number 24.
Report is have we heard earlier?
Yes, my lord, in fact, hearing was concluded.
Okay, yes, yes.
Yes.
Because certain and then some more judgments still remain.
My lord, my lord.
I have
No
CAB, and then because of lack of time.
No problem, my lord. Lordship can take your own time, my lord. No problem. Hearing was concluded in fact, my lord.
Okay.
Yes.
It is the where is submit?
Yes.
Why appeal? Why not revision?
My lord,
and
this
say-
is as per the CRPC. If convicted,
where is the provision?
my lord, also CRPC.
Yes.
Because the punishment is lesser. So
Yes.
therefore, it doesn't
Let
come
us see
under-
the provision. Because this is revision.
My lord, this is revision, my lord. Sorry, my lord, my colleagues.
Okay. CRPC. What is the minimum punishment here? 3 years, I think. No, give it. Minimum.
6 years, my lord.
Minimum is 6 years.
No, maximum,
No.
maximum 6.
Maximum. So
Yes.
the learned judge has
So
given
therefore,
maximum.
yes. Learned judge has given maximum.
Maximum.
Yes.
So that is why I was looking for
Yes.
the appeal. If it
Yes.
is appeal,
Ah.
then can be brought to the minimum or the sentence undergone also. But then if you in the revision, again, is it? I
In
find
fact-
it little difficulties.
My lord, in fact, this gentleman, the accused, he has served for almost the whole sentence.
That is why I'm saying, why not appeal? So and then here, okay, yes, please,
Yes, my lord.
please.
Yes, you can, lordship.
Find out that first. And then here, what I found
Yes, my,
is the learned trial judge
yes,
has also,
Hmm.
apart from certificate, of course, the
Yes.
content of the certificate,
yes.
although the certificate has been exhibited, but the content of the certificate has not, what
Proof,
your
no proof,
contention is not
no
proof.
Yes,
But then the learned judge,
yes,
the trial judge,
yes.
has made a
Observation.
observation
Yes.
that on appearance also,
At paragraph 10,
yes.
I've gone through, my lord.
Hmm.
My junior
On
informants have
appearance
gone
of,
through.
appearance of victim found found to be a child. So
Yeah.
how do we come across
That is
this?
what. Lordship will appreciate.
Observation.
Lordship will appreciate.
Hmm.
Lordship has a lot of experience.
Hmm.
Now,
Hmm.
in order to determine the age of an alleged victim under POCSO Act,
Hmm.
JJ Act is always made applicable to determine the age.
Hmm.
Then the JJ Act section 95 says they have classified how to conduct the test. So now JJ Act 95 section 95 says 94. I'm sorry, JJ Act. Where is the flag? Lordship, I'll just read out the JJ Act, Rule 94,
JJ Act.
Section 94.
Hmm.
This is the statutory law governing the law how to determine the age of an alleged minor. So beyond this, there is no law, and I have a Supreme Court judgment. Therefore, the Lordship will appreciate. Yes, JJ Act 94. His Lordship is making a query. 94, JJ Act 2015. Let us JJ Act 2015, man.
Yes.
Section 94.
Yes.
Lordship, I'll just read out, my lord.
Hmm.
Presumption and determinations of age, where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provisions of the Act, within bracket, other than for the purpose of giving evidence, close bracket, that the said person is a child. The committee or the board shall record such observations stating the age of the child as nearly as may be and proceed with the inquiry under section 14 or 36 as the case may be, without waiting for further confirmation of the age. 2. In case the committee or board has reasonable ground for doubt regarding whether the person brought before it is a child or not, the committee or board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining.
This is in respect of the accused.
Correct. No. Victim.
In respect
Victim.
of victim. Since the charge, since it is under POCSO Act,
Yes.
charge sheet was filed before the POCSO
Correct.
special judge.
Yes.
Then how do this?
JJ Act.
Hmm.
Because Lordship will appreciate under POCSO Act to the